All right, ladies and gentlemen, welcome on this wonderfully beautiful day. It's, I think, the most beautiful day we've had all spring. And here you are inside. And you are in the right place because this is going to be a terrific presentation. So for those of you who don't know me, I'm Michael Scharf. I'm the co-dean of the law school. And it is my great pleasure today to welcome you to the 2019 Brahms Endowed Lecture, which is presented by Professor Brian Adamson, who is right here in the front row, and you'll be seeing him in just a minute. Brian will be speaking about the Supreme Court's controversial Masterpiece Cakeshop versus Colorado Civil Rights Commission decision. And we are absolutely delighted to have Brian back at Case Western Reserve. Many of you don't realize or know that he is actually a 1990 graduate of our law school. And he went on to come back as a professor in our clinic. And he also served as our assistant dean for student services from 1995 to 2002. Prior to joining our faculty, Brian was an attorney at the Cleveland law firm of Squire Sanders, now Squire Patton Bogg, and he was an assistant prosecutor with the Cuyahoga County prosecution. He is currently a professor and director of clinical programs at Seattle University School of Law. He is a prolific writer, and in 2016, he was awarded Seattle University's Award for Excellence in Research and Scholarship. He's a national leader in experiential education, and Brian served as the former chair of the American Association of Law Schools section on clinical legal education. He was recently awarded the prestigious William Pincus Award for Excellence in Clinical Legal Education by the Association of American Law Schools. I could go on and on and on, but you really want to hear Brian, and this is really going to be a fabulous presentation. So without further ado, please join me in welcoming Brian Adamson.
Thank you for that nice introduction. I'll do it justice. I hope that y'all can hear me okay? Okay, all right. First, some thank yous and some honorifics, or some honoring. I want to thank you, Eileen. I want to thank you, Professor Dean Berg and Dean Scharf, for inviting me back. This is a wonderful tribute and a wonderful place to be after, oh goodness, not being here for 17 years and returning. So it's been great. It's been great to be back and to be welcomed and to see so much positive change that has happened to the school, but also some wonderfully familiar things about the school, including some of the faces that I have here, some of my mentors now and colleagues and now friends, Professor Katz, Professor Enton, Professor Lipton, Professor McKinney. I'm so grateful for them, for their friendship, for their relationships, and my new friends in clinical community with me here today. And so I just needed to give that honor and thanks for this. And so I hope you get something from this, and I most importantly hope that you can help me sort of flesh out some of these ideas and thoughts that I have about Masterpiece Cakeshop. This presentation is called Pretextual Orientation, Testing Religious Insincerity After Masterpiece Cakeshop. Now, last year, before, in December 2017, when the oral arguments were had in Masterpiece Cakeshop, I had to admit that upon hearing those oral arguments in December 2017, I was then reading the postmortems. I was sure my tea leaves and the pundits were wrong. That is, odds were that I thought that the Supreme Court would deal a crushing blow to LGBTQ rights, right, by ruling in favor of Jack Phillips. And Jack Phillips was the baker who, on grounds of his religious convictions, had refused to sell a cake to Charlie Craig and David Mullins for their post-wedding celebration. I recall having this dreading, this foreboding in the pit of my stomach, because I believed that the court just might rule in his favor. But I couldn't fathom how the court could issue a ruling without wholly undoing the protections that against discrimination that were accorded, right, by public accommodation laws in those states, including Colorado. And not just those that ban discrimination on the basis of sexual orientation, but those that ban discrimination on the basis of race and gender and et cetera, right? So while I suspected that maybe three of the justices, right, the usual suspects, Thomas, Alito, Gorsuch, would be willing to create a free speech exception to such laws, I just couldn't get to five. But upon reading the decision, I realized, of course, that my fears were dashed. Despite affirming the Colorado law, that Colorado law could protect gay persons just as it could protect other classes of individuals in acquiring whatever products and services that they choose on the same terms and conditions as offered to other members of the public, and acknowledging that the baker, in his capacity as the owner of a business serving the public, might have his rights to free exercise of religion limited by generally applicable laws. The Supreme Court, in a 7-2 decision, ruled that the Colorado Civil Rights Commission and the Colorado Court of Appeals had failed to give, quote, neutral and respectful, end quote, consideration of Phillips's sincere religious beliefs. And so the case was not decided on free speech or free exercise grounds, free exercise of religion grounds, strictly, but on a decisional basis that seemed to me just to be so narrow to render its reasoning almost inexplicable. Right? It left me wondering whether the court should have brought the case at all, should have heard the case at all, right, and brought it to decision. And as Justice Ginsburg noted in her dissent, they were hardly the types of comments made by members of the commission that in past cases have given the court constitutional pause. So my thesis is kind of this. So I come at Masterpiece Cakeshop in the context of what it might mean or doesn't mean for LGBTQ rights, and what it means or might not mean for free expression and critique of procedural processes. But this has been one of the issues that's been concerning me about this case, about Masterpiece Cakeshop and this decision, where the evidence of anti-religious animus was so weightless, so misconstrued, because the case had multiple layers of independent review, right? And it's a wonder why the case, like I said, the court decided to take the case, or upon taking the case, it didn't decide to dismiss it as improvidently granted. And I'll get to that in a moment. But my other concerns also extend to, at a minimum, what at a minimum constitutes hostility towards one's religious beliefs, the implications of carving out religious belief exceptions to generally applicable non-discrimination laws, right? And I don't come from Masterpiece so much as a law and religion scholar, because I'm not, but I do have questions. And I still have more questions than purported answers on that score, right? I do wonder whether Masterpiece Cakeshop opens the door for those who might use religion as a pretext for discrimination, and if so, what that bodes, right, for the Supreme Court's quote-unquote no orthodoxy principle and the court's avoidance of certain inquiries into a party's religious beliefs. So this is what I'll try to do in the time that I'm allotted in the next 20 minutes, 3 points. I want to talk a little bit about the decision and some observations about it. Secondly, I want to talk about how the decision might square with other court doctrine regarding illicit motives or animus. And then finally, I want to talk about the decision itself and what it might mean for current and future assertions of discrimination based on religious belief in the enforcement of generally applicable anti-discrimination laws. So what happened? July 2012, Dave Mullins and Charlie Craig, they were planning their wedding, right? They were planning a wedding reception in Denver, Colorado, but they were getting married in Massachusetts, right? So with Craig's mom, Deborah Mum, they go into Jack Phillips's bakery, right, which was in Lakewood, Colorado, a suburb of Denver. And he sells wedding cakes in that shop and other baked goods to the general public, right? They sat at a table and that table had a book on it, an album with pictures of Jack Phillips's cakes on it, right? In it, right? And according to Phillips, they told him that they were there to pick out a wedding cake, that it was for them. He told them immediately he does not create wedding cakes for same-sex weddings. And Phillips says that they had a brief exchange, and he said that, he could create birthday cakes, a shower cake, or any other cake, but he just wouldn't create a cake for their wedding. He says he believes they may have talked over one another for a few seconds, but then they left. After that, Mullins and Craig filed a complaint with the Colorado Civil Rights Division, alleging that Phillips had violated their civil rights in contradiction to Colorado's Anti-Discrimination Act. It's called CADA for shorthand. And that act prohibits discrimination based on, amongst other things, sex and sexual orientation. Now, after notice and investigation and a hearing, the Civil Rights Division director determined that there was probable cause to issue an order, or ruling rather, that Jack Phillips had indeed violated CADA and violated the rights of Mullins and Craig. Now, after that, adjudicative proceedings were held on appeal, held before an administrative law judge, which affirmed that determination, ruled against Phillips, and that ruling was then affirmed by the Colorado Civil Rights Commission. Now, that commission is composed of 7 individuals, and they ordered Phillips, of course, to cease and desist from discriminating against same-sex couples by refusing to sell them wedding cakes on any product that they would sell to heterosexual couples. Seems simple enough. Phillips then appealed to the Colorado Court of Appeals, and while in the Court of Appeals, the commission rejected a discrimination claim of William Jack. William Jack alleged that 3 different bakeries had discriminated against him because they refused to fill his orders for cakes that bore derogatory or pro-Christian messages about gay people. But the Court of Appeals took in that information and affirmed that denial of William Jack in a footnote. As to the main case, however, the Court of Appeals affirmed the decision of the commission and decided that, yes, indeed, the commission's decision as to Mr. Phillips would stand. He then appealed to the U.S. Supreme Court, renewing his free speech and free exercise claims. A little bit of digression about the free speech claim and the free exercise claim, just for points of information, because really the courts, like I said, did not even visit those issues, but it's important to get that context, I believe. So what Phillips argued basically is that the law forces him to speak. It tells him to speak, to make a cake for a same-sex wedding in contradiction to his religious tenets. Now, if making a cake is merely conduct, then there's no First Amendment violation, right? First Amendment speech claims don't apply in that situation of conduct. But to raise a legitimate First Amendment claim or speech claim or compelled speech claim, Phillips has to make the case that a cake for a same-sex wedding forces him to endorse the marriage, and that making that cake is expressive behavior, which does enjoy First Amendment protection. Now, it is not speech, of course, in a literal sense, but could be characterized as expression if 2 conditions are met. If there is an intent to convey a particularized message, and that intent was present, and if the surrounding circumstances were great that the message would be understood by those who viewed it. 2 seminal cases that reached the issue of freedom of expression and First Amendment were invoked in this particular case. Hurley, which dealt with the Boston Irish American parade, and Dale versus Boy Scouts, which dealt with the admission or allowance of gay members of the Boy Scouts to serve as troop leaders. And there, the Supreme Court, only on the narrowest margins, particularly in the Boy Scouts case, stated that those organizations had strong expressive association claims, right? So, but as Ginsburg rightly noted in her dissent in Masterpiece Cakeshop, With regards to what can be constituted as expressive content, the key is what the ordinary observer would understand the message the cake was communicating, and critically, who is communicating the message? Is the baker communicating the message, or is the person asking for the cake communicating the message out of the cake, right? Because of the cake. What becomes factually and constitutionally even critical is whether Phillips was asked to make a cake, or was he asked to create a cake? Whether it was a cake celebrating same-sex marriage, or just asking somebody to put some flour and sugar and eggs together and whip it up, right? Those distinctions, those descriptions make a factual and even a constitutional difference that the court didn't really wrestle with in this case, I think regrettably, right? So that's free speech aspect of this case. There's also this free exercise issue that was raised by Phillips. What he had to do was argue that the Colorado Public Accommodations Law, the CADA, violated his rights to practice his religion without undue interference required. And it required him to look at the free exercise clause. Now, laws that burden religion are subject to two levels of scrutiny, right, under the free exercise clause. So neutral laws, that is facially neutral laws, generally applicable laws burdening religion, are subject to just rational basis review, right? While laws that discriminate against some or all religions or regulate the conduct because it's undertaken for religious purposes or religious reasons, they're subject to strict scrutiny. But because this particular law, this CADA law, was neutral on its face, it did not burden unduly or specifically or preferentially religion. Because it was neutral on its face, Phillips would not likely have prevailed on a free exercise claim because the rational basis standard is so easy for a state to justify, right? The state has a legitimate interest, right, in anti-discrimination laws. And that could be easily shown, and some, of course, including myself, would maintain that the states have more than that, right? That they have a compelling interest to ensure that anti-discrimination laws are enforced. And so I would say that it would have surpassed strict scrutiny as well. But what the court does, it doesn't visit free exercise or free speech claims. It does, however, in ruling in favor of Phillips, cite a case that it had cited on several occasions, and it's cited for a very important proposition, and that's the Church of Lukumi Babalu I versus the City of Hialeah, Florida. And it uses that case to buttress its edict as to what a decision maker, like the commissioners in this particular case, are supposed to do and what they're not allowed to do when they are visiting questions about whether or not someone's anti-religious animus is animating their decision not to comply with the anti-discrimination laws. Right. Now, in that case was brought by citizens who practiced Santeria, which is an Afro-Caribbean religion. And they announced that they were going to build a church in Hialeah. In response, however, the city council adopted several ordinances addressing religious sacrifice, which was a part of the tenets of that particular religion. The court held that the ordinances were neither neutral nor generally applicable because they were made in response to and singled out the activities of that religious group and only that religious group, right? And this was a legislative body that had done this. Now, the ordinance's legislative history, including the enactment of numerous exemptions for members of other religions, evidenced a clear intent to target practitioners of the Santeria faith and none else. And that is why the court in that case held those ordinances to be unconstitutional. Where I part ways with why this case even showed up in Masterpiece Cakeshop is the fact that we're dealing with different provisions, right? Masterpiece Cakeshop was a facially neutral, generally applicable public accommodation law, right? And how it was applied to a set of facts was the issue. You had two commissioners out of seven who expressed anti-religious animus, right? You had independent review, and you had once again, a facially neutral statute. And there was no indication also that the the ultimate decision of the commissioners was infected by the other two. That is to say, there was no indication that the 5 of the 7 commissioners who said nothing ascribed to the views of the 2 who expressed this anti-religious animus. You didn't have those facts in Lukumi, right? In addition, Lukumi involved the legislative body, right? A law that's on its face, once again, that was not neutral on its face, and that, from all evidence of the legislative history, targeted a particular religion. So those are my problems with that particular decision. But nonetheless, they held in favor of Phillips's claims. Now, Gorsuch, Alito, and also issued concurrences. Now, all 3 of them would have reached this free speech argument. Justice Gorsuch, joined by Alito, argued that the Colorado unfairly privileged sanctioning Phillips' refusal to provide a wedding cake to same-sex couples as tantamount to the exclusion on the basis of sexual orientation. In other words, while failing to treat refusals to produce William Jack's cakes, that was equal or as bad as discrimination on the basis of religion, is what they were saying. They saw this double standard of sexual orientation and discrimination at play. And so did Thomas, but Thomas gets to the First Amendment issue only by, or I should say the free speech issue, only by untethering this Mullins and Craig's gay identity and same-sex marriage and Phillips's conduct, his refusal to make a cake. However, the Supreme Court has rejected precisely that kind of status conduct distinction in cases involving statutory and constitutional claims of discrimination. For example, laws that preclude same-sex marriage to discrimination on the basis of sexual orientation do so because those who are of a different sexual orientation only engage in that type of conduct, that is, same-sex marriage. But Thomas even goes farther, though, in his willingness to strike down CADA as violative of Phillips's free speech rights. Once again, like he's done in past cases, he again rejects the stigma and dignitary issues or dignitary interest principles that undergird the majority's opinion, and indeed have undergirded Kennedy's, who wrote the majority opinion in this case. I think I said that right. His cases beginning with Roma versus Evans on up to Obergefell, that dignitary interest and that stigma interest and those principles that animate this inclusion of LGBT folks in the array of constitutional rights, right? And indeed, Kennedy's majority opinion in the seminal gay rights cases, like I said, and from Roma to Masterpiece, talk about this. But Thomas also sees that double standard in protecting these or privileging certain types of speech. But he does so in a different way. Basically, what he says is that he sees the Supreme Court rejecting anti-gay expression, as they're doing here with Phillips, but sanctioning anti-black expression, as the court did in Virginia versus Black, as the court did in Brandenburg versus Hayes, where issues of KKK expressive conduct was at play. So he sees a double standard on this racial and racialized continuum. More on that later. I got issues with that. But concluding the case discussion. So they don't get to the First Amendment issues, right, as to whether or not compelled speech or the law violates free exercise. They don't get to that. The Supreme Court reversed the Colorado Court of Appeals, right, by finding hostility on the part of 2 of the 7 commissioners, and that hostility was inconsistent with the First Amendment's guarantee that our laws be applied in a manner that is neutral towards religion. The Supreme Court held that the state manifested an anti-hostility by disparaging Phillips' religion. And there were 2 statements that the majority glommed on to support its conclusion. One of the commissioners said the following: if a businessman wants to do business and he's got an issue with the laws impacting his personal belief system, he needs to be able to look to compromise. That was one. All right. The second statement, one of the other commissioners said, quote, slavery and Holocaust were justified by religion. It is one of the most despicable pieces of rhetoric that people can use to use their religion to hurt others, end quote. Stepping away is my personal hat. I'm looking for the lie, but I'll put that to the side. I'm trying to find the lie in those two statements. But the Supreme Court rested their decision on those two statements as exhibiting anti-religious animus, plus the fact that there was no rebuke of those assertions by the other 5 commissioners, right? In addition, the concern was that the state enforced a double standard, as I said before, in the way in which it prosecuted Phillips's claim versus the claims of William Jack, who actually was a ringer who went to these particular bakeries and asked for these particular cakes, was denied, and then filed the action. And, that's not unusual, right? We have testers for housing discrimination. People do that. I should say people engage in that type of behavior to bring attention to legal distinctions, to bring attention to discrimination. So not too much can be said about that. But he did what he did. But his complaint made it into the Court of Appeals and then the Supreme Court decision. But while Phillips did ultimately prevail, he did so on the narrowest precedential ground. The Supreme Court did not, as I said, resolve the dispute by clearly affirming that LGBTQ people are protected by the Constitution from discrimination, even if that discrimination was based on religious beliefs. Didn't resolve that. But nor did it resolve the issue of whether cake making amounts to speech or free expression, and thus cannot be constitutionally compelled under the First Amendment. And finally, nor did the Supreme Court visit the argument that would read a religious exemption into generally applicable public accommodation laws. So once again, my quarrel is, why did this court take this case in the first place? All right. I think that the Supreme Court should have dismissed it as improvidently granted, because we just don't know precisely what Phillips refused to do. I'll get that in a second. So when the Supreme Court grants a writ of certiorari that, upon further consideration, appears ill-advised, it need not take the case to full decision. It doesn't have to. Now, under some circumstances, the court will dismiss the action and not take its decision as improvidently granted. I'll call it DIG for short, dismissed as improvidently granted. Keep from saying that long word over and over again. The Supreme Court has not formally defined what DIG means, however, nor has it established clear standards for reversing a writ of certiorari, right, based on that standard. Circumstances arise whereby, after a case has been accepted, the issues, for example, become moot, or the court realizes that it's without jurisdiction to hear the matter. Now, the most well-accepted reasoning for DIG is because circumstances which were not fully apprehended when certiorari were granted have now arisen. There are other reasons. A failure of the record to present a question which the Supreme Court is expected to answer that the Supreme Court was expected to answer when it first granted cert, or there is an inadequate or an unclear record. Right? So it does bring a set of intellectually challenging and actually practically important issues that are raised by the court's behavior and its exercise or its refusal to exercise the DIG. Most notably, the court has long used, right, a rule of 4 to determine the minimum number of justices needed to agree to a writ of cert and whether or not that should be granted, right? Now, how many votes are needed for a DIG? It's unclear, right? If it's only 5, then actually, it kind of nullifies or makes moot the rule of 4, right? When you can have one of the 4 justices have a change of heart, change his mind, change her mind, and the proprietor reviewing the case in the first place. So that doesn't make any sense. Maybe it's a supermajority, requiring like 6. So at least one more justice or 2 more justices have to have changed their minds about the propriety of accepting the case, right? But then there are also jurisprudential questions about what reasons ought to justify a dig, as I was saying before. I mean, should it be enough that a majority or a supermajority of the justices simply think that the original grant was wrong? That doesn't seem to make much sense. Or should additional or different reasons be given or necessary, right? Finally, should the court as an institution or the justices individually always issue opinions explaining their decisions not to, or their decisions to dig, right? Now, of course, just because any of those situations that I mentioned before that would justify a dig, that they may exist doesn't necessarily mean that the court will withdraw cert or anything like that, right? But it's this failure to present the question or the inadequate record justifications that give me pause in this particular case. Because you look at the facts of the case, Craig and Mullins said that they told him immediately that he told them immediately that it was his standard practice not to provide cakes to customers who were purchasing a cake for a same-sex wedding, right? They voiced their objections and then left without having the opportunity to taste the cake, without having the opportunity to take samples, or to even place an order for a wedding cake. Now, according to Phillips himself, and he swore to this in his response to the complaint, right? He said the interaction lasted no more than 20 seconds and was undisputed, as Phillips, once again, he says this himself in his sworn statement, is that he immediately stated that he does not provide cakes for same-sex weddings, and that Craig Mullins nor his mother told Phillips what they wanted the cake to be or what they wanted the cake to look like. They never had the chance. So if there was no discussion of a cake, right, there's no First Amendment issue. There's no freedom or free exercise issue, right? There was nothing. There was nothing, only status that he based the decision on, right? And so there's no constitutional issues to adjudicate. Y'all got to help me out on this because I don't know if I'm right, but it just didn't make sense to me, all right? I have other problems with the case. This idea that it seems to articulate a new standard for religion and anti-religious animus that's not available when other decision makers exhibit hostility. So just a few weeks after Masterpiece Cakeshop was decided, just a few weeks after that, the Supreme Court refused to halt the execution of Charles Rhines in South Dakota, even though it looks like he was given the death penalty because he's gay. Charles Rhines was tried for robbing a store and stabbing to death one of his employees. And as I said, Charles Rhines is gay. His sexuality was known to jurors as it was referenced throughout the trial proceedings. Right? The jury found that Rhines was guilty of first-degree murder and third-degree burglary. But during the penalty phase of the deliberations, the jury sent out a note to the judge with a list of questions. Including those questions were, quote, would he be allowed to, quote, mix with the general inmate population, end quote, quote, create a group of followers or admirers, end quote, quote, brag about his crimes to other inmates, especially new and or young men, end quote, quote, marry or have conjugal visits, end quote, or have a cellmate. All right. The trial court responded, right, dear jurors, I acknowledge your note asking questions about life imprisonment. All the information I can give you is set forth in the jury instructions. It refused Rhines' attorneys' proposed admonition, right? The attorneys wanted the judge to add the following disclaimer or admonition. You are further instructed, however, that you may not base your decision on speculation or guesswork. Of course, the jury recommended the death penalty, and the judge agreed. Now, on appeal, Rhines argued that this allowed the jury to improperly speculate about life in prison. Rhines argued that the jury note demonstrates the jury bias toward him and that the trial court did not adequately respond to those improper questions. As a result, he argued that the verdict should be set aside despite this the state rule or constitutional rule of no impeachment, where you cannot impeach or overturn the decisions or what's the basis of decisions of a jury. And he said that the state's no impeachment rule should be overturned because this violated his Sixth Amendment right to a fair and impartial jury. But when he appealed, he brought receipts. He had 3 affidavits from the jurors, right? One juror stated that the jurors knew that Mr. Rhines was a homosexual and thought that he should not be able to spend his life with men in prison. Right? Another affidavit, a juror in the affidavit recalled that hearing an unidentified juror comment of Rhines that if he's gay, we'd be sending him where he wants to go if we voted for life imprisonment without possibility of parole. A third juror confirmed that there was lots of discussion of homosexuality. There was a lot of disgust. We're a farming community. There were a lot of folks who were like, ooh, I can't believe that. His arguments were grounded in a Supreme Court case, Pena-Rodriguez versus Colorado. I know Aisha's familiar with that, tongue-tied, sorry Aisha, is familiar with that case. And that case held that the same in the context of a juror who relied upon improper stereotypes about Hispanics to convict the defendant. The Supreme Court held that Pena-Rodriguez didn't apply because the basis of it was on the basis of race, where you had here was a discrimination on the basis of sexual orientation, and therefore they didn't have to extend Pena-Rodriguez to this particular case of abject and utter anti-gay animus. So what did the U.S. Supreme Court do? They denied cert in that case, in the face of all of that evidence. That's not my only problem with the case. I got a few more minutes. It has to do with the legislative enactments of an illicit intent. One remarkable thing that Kennedy did in Masterpiece Cakeshop is set a terribly low bar in finding that a member of a body, a deliberative body, demonstrates anti-religious hostility, and saying that it effectively nullifies the decision of the entire body. Now, aside from the weak support that Lukumi offers for that proposition, as I've contended, Kennedy suggests that there's a presumption of unconstitutionality that attaches to any adjudicative decision tainted by illicit motives as it regards anti-religious animus. Now, this is remarkable, especially in light of the court's jurisprudence around equal protection and race discrimination, as well as its jurisprudence on legislative intent and gerrymandering in voting rights cases. Like, for example, in the equal protection cases and the racial discrimination cases, a plaintiff claims racial discrimination and shows that there were illicit racial motives on the part of a defendant. Then the burden on the part of that's part of the government, right? The burden shifts then to the government to demonstrate that either there was no discrimination, or that the outcome, its decisional outcome, would have been the same despite any evidence of racial animus, right? And as it regards gerrymandering, right, decisions by legislators are viewed as collective, such that even if one of many legislators has an illicit racial motive in a particular formation or forming of a legislative district, that won't undermine the overall correctness or legality of the districting, right, as a general matter. But what Kennedy and his brethren do for anti-religious animus, they do for no other type of animus. And what they do is they dispose of that but-for causation requirement, right? In Masterpiece Cakeshop, it infers that the commissioner's comments were not nullified by others, but instead treats others' silence as assent, right? So this inference of ill motive of a collective decision even where there's evidence that a few are racist, doesn't obtain in any other case but here now, right? And finally, one of my other questions about this case has to do with Trump versus Hawaii. And I'm not the first nor the only to consider this opinion in light of and in contrast to the majority opinion which Kennedy joined in that case, which upheld President Trump's travel ban. and willfully and egregiously ignored, or at the very least minimized, the abject anti-Muslim, anti-religious attitudes and beliefs explicitly espoused by Trump, and that informed the content and the structure of Executive Order 13769. Right? It was clearly offensive and hostile as anything those two commissioners said at the Phillips hearing. And then Kennedy issues a short concurrence in what I can only characterize as sort of a weightless scolding, where he says that there are numerous instances in which statements and actions of the government officials are not the subject of judicial scrutiny or intervention. The First Amendment promises free exercise of religion. From these safeguards and from the guarantee of freedom of speech, it follows there is freedom of belief and expression. It is an urgent necessity that officials adhere to the constitutional guarantees and mandates in all of their actions, even in the sphere of foreign affairs. This reticent reproach of Trump's statements stands in stark and, in my mind, very damning contrast to his findings of anti-religious animus, where a commission says a businessman needs to look to compromise. Justice Sotomayor calls him out in a way in her dissent in Trump versus Hawaii, and she draws the parallels to Masterpiece Cakeshop that was just cited a few weeks before. And in both instances, the question is whether a government actor exhibited tolerance and neutrality in reaching a decision that affects individuals' fundamental religious freedoms. But unlike in Masterpiece, where a state civil rights commission was found to have acted without the neutrality the free exercise clause requires, the government actors in this case, in the case of Trump versus Hawaii, will not be held accountable for breaching the First Amendment's guarantee of religious neutrality and tolerance. Unlike in Masterpiece, she continues, where the majority considered the state commissioner's statements about religion to be persuasive evidence of unconstitutional government action, the majority here completely sets aside the president's charged statements about Muslims as irrelevant. So, wrapping up, in the wake of Obergefell, over 100 laws attempting to protect the rights of religious individuals and organizations have been initiated and enacted. And 23 states now have religious freedom restoration acts. And now we have litigants arguing and in administrative hearings and tribunals regarding and asserting discriminatory anti-religious animus based on denials and based on refusals to serve people on an equal footing. In addition, many states have introduced First Amendment defense acts that prevent the government from taking action against any person on the basis of his or her belief that marriage is a union between one man and one woman. The fact is that religious insincerity, in my opinion, causes two types of harm. Right? There's this harm of fraud, either on private parties or on the government. And there's this false accommodation claims, either against a private employer or a government. And it's not to say that certainly the vast majority or most of those who are asserting religious convictions as objections to their refusals to take certain actions on behalf of same-sex couples or homosexuals, or that they're all animated by illicit motives. But it is to say that there are costs associated with ignoring the false claims, right? And given the cost of ignoring religious insincerity, the government should not hesitate, in my mind, to call it out when it has reasons to doubt a person's credibility. You know, courts and government officials adjudicate religious sincerity in a wide variety of contexts, right? Fraud, immigration rights, employment discrimination, prisoner religious accommodations, conscientious objection from service, whole nine, a litany. And while there's no reason, once again, to doubt the sincerity with which most walk in religious beliefs, we must contend with how those beliefs are accommodated and respected, in the commercial arena, while not denying individuals the structural inequities that would come from the cascade of exemptions one might claim from neutral, generally applicable laws. Religious liberty does not, nor should it, entail the protection of phony religious claims. So in conclusion, as a result, on one hand, the court failed to extend Obergefell versus Hodges' seismic conclusion, right, that any prohibition on same-sex marriage is a violation of the Equal Protection Clause and the Due Process Clause of the 14th Amendment. But at the same time, Phillips won the battle but lost the war. He did not, and the court did not elevate his grievances to the level of constitutional claims. In my mind, the biggest winner was perhaps William Jack, who kind of got his 15 minutes, right? At bottom, however, even though accepting the case at the end of the day, which I still take quarrel with, I just maintain that Masterpiece decision gave a little nothing to everybody. That's it. Thank you.
So we do have about 15 minutes for questions, and I know a lot of people have thoughts. So Eileen has the microphone, and you just raise your hand, she'll hand it to you, and please wait till you get that so that you will be on our webcast.
Thank you. I wanted just to ask a question about what you said, which you put as kind of an aside comment, which is whether truth matters with regard to religious claims. If the Southern Baptists have apologized, for what it's worth, for their stand on slavery, and the Catholic Church has apologized, for what it's worth, for its stand on the Inquisition. So if local Baptists or Catholics said our religion misbehaved in conformity with their own religion, would that be, under the jurisprudence that you're suggesting, a disqualification for them because they're making anti-religious comments? I mean, does truth matter here at all, or is this just either fawning and following of religion, even when the church itself recognizes its past history?
Yeah. If I understand your question right, I'll try to answer. You let me know if I'm not answering it correctly. The Supreme Court particularly, has always demonstrated a reluctance to get into questions of the truth or the accuracy of one's faith, right? It gets in certain circumstances, we'll get into the issues of the credibility and the verifiability of one's adherence to certain beliefs. And that does, I think, elicit a lot of questions that you have to ask. But the no orthodoxy proposition and principle that's been around, for decades now, animated in the Supreme Court decisions, makes them very reluctant to really inquire into religious beliefs on one hand. But then we've seen it in other cases and circumstances where they have asked about a person's sincerity of holding certain beliefs or certain tenets or certain acts as part of or animating their religious beliefs. They try to get at truth, but this issue, they tiptoe around this issue of trying to get at the core of people's religious beliefs. I don't know if that answers or not, but they're very reluctant to do that.
Brian, we can speculate about sort of why the court did what it did. We don't really know the internal dynamics, no. But I guess I was struck by something about Phillips' free speech claim, and it's something that we've seen in Hobby Lobby and other cases involving the contraceptive mandate. The idea is that Phillips claims, if we take him seriously, he claims that he is complicit in this marriage that he finds religiously or morally unacceptable. Yeah. And the challengers to the contraceptive mandate have also made a kind of complicity argument. Indeed, at least some of the challengers have objected even to the act of filling out one piece of paper to send in. Yeah. And I'm just wondering, how should the law treat these sorts of claims of complicity without getting into the sincerity of the belief, but just, is there a way for the law in a principled way to deal with claims of complicity in these situations?
Thought about that, but this is one of the things that immediately comes to mind is line drawing in terms of what an act means, and what that act means, and who it means to, for lack of a better. Let me just think of an example. When, for example, the cake. Does Phillips making a cake say that making this cake associates me with gay marriage, something that I object to because of my religious beliefs, right? One of the ways to, I think, cut that proposition off is to suggest that it doesn't necessarily mean that you endorse that, because you endorse, you do things in other realms that you might not otherwise endorse. Maybe one example is, okay, you make a cake for an atheist. Does that mean you endorse atheism? You can ask Phillips, you make a cake for a Muslim wedding. Does that mean that you endorse the religion of Islam? And maybe if the issue is what it means to associate oneself with a particular position or stance, the other, I think, response to that could be, well, you're a business that you have to serve all. No one would necessarily claim that just because you made a cake for a same-sex wedding that you endorse same-sex weddings. I don't know, John. I don't know.
She has a question, and then you.
Sidebar. I don't know. Yeah.
I mean, that's what it comes down to, in my opinion.
Say that again?
I used to make cakes.
Oh, okay. Aha.
Yeah, I'm a former pastry chef.
Okay.
I mean, and it's, is the product line of the Masterpiece Cakeshop a religious expression? I would think of companies that make the communion wafers as a contrast.
All right.
Because yes, that is, and that is a product line, which is, in my opinion, would be a religious expression dedicated to it.
Yeah.
But okay, I mean, so is the product line at the Masterpiece Cake Shop, devoted to his religious expression?
Doesn't seem to be exclusively.
To me, he's there to make a buck.
Yeah, cool.
And
For
I mean,
profit.
that's the purpose of opening your business.
Yeah, yeah.
So, sorry.
Thank you for that. That's all right. Yeah, that's all good. That's all right. That's something.
I like where you're
That's
going.
all right. I like where you're coming from, though.
As a retired attorney and professor, I'm going to take the bigger view and not necessarily the legal analysis, and just say that what I'm seeing is a trend to use religion to cut back on the rights of people, on rights that the court is squeamish about.
Yeah.
yeah,
Go ahead, continue, or you want me to? A brief response to that. So two things that have come to my mind listening to that, Louise. One, this idea of weaponizing the First Amendment. Justice Kagan wrote about it last year, or what decision was it? Thank you. Yeah, Janice. So there were two opinions or two decisions that came out of the Supreme Court. The same term as this, right? The Janice decision that dealt with public unions and their ability to withhold without consent monies to use for collective bargaining. And then there was another decision that came out that same year with regards to undercutting or striking down California's law that required organizations that counseled women, religious-based organizations that counsel women about planning, about family planning, had to give them a list of places where they could get abortions. They objected to that, and the court struck down that California law. So those were examples that Kagan wrote about in Janus that talked about how the Supreme Court, particularly under the Roberts Court, is doing something very interesting and insidious, some would say, of weaponizing the First Amendment. That is, sort of using the First Amendment in a way that's typically been used by liberals and libertarians, right? And so they're kind of using this now to advance issues such as, it's my religious right not to be compelled to do something. It is my right to not support unions. It is my free speech and free association rights to do X, Y, and Z. So I see that, and no one talks about this case necessarily in that context, but I see that in this case a little bit as well. Mm-hmm.
My earlier comment really it comes down to the same point that it's a business, and the use of the word endorsement, illuminates that distinction. Nike pays a whole lot of money to endorse figures they want to promote. It's not the other way around. He got paid, or would have gotten paid, to make this cake, and I appreciate the line of thinking that, and even the company, arguably, that makes wafers for communion. I mean, my Jewish great-grandfather landed here and started a Christmas tree company. It's time to, it's making money. And I think the healthcare, the contraceptive, or family planning issues can similarly be, defined as a line of business or activity, purpose-driven, that isn't intended to be a religious expression.
Yeah. Well, that's behind the whole protections, trying to protect these public accommodation laws. The idea of their purpose and reasoning. I think that's part of that. Legitimately, the whole business motivation of anyone, right? Yeah. Yes.
Yes, I look at this as a more morality issue than being Muslim or being another atheist. So I think that's what the problem is here.
Yeah, and I think that, I have no better response to that than what you just said. This other issue, though, has to do with what they call sort of like the structural inequality that just sort of courses through these arguments against these accommodations. Is that this refusal or unwillingness to treat LGBT folk in the same way, in the same manner, ignores, as they do other groups, other historically disadvantaged groups, just sort of ignores the structural inequalities that have been erected to keep them outside of life, right? Keep us outside of life for forever, right? And so we have to think about it in that sense too. That there's these public accommodation laws are ways of pushing against that and dealing with that. As someone said, this case is no more about cakes than someone sitting in a diner was about getting some food, right? There's no difference. Someone back in.
I am Joanne Fabric, and these people come in and they want to buy some cloth to make KKK robes. Do I have to sell them the cloth?
Ha ha.
They got a pattern, and
he's my guru.
or maybe I got a pattern to make like a devil worship kind of concept. Do I have to sell them the cloth?
Are you private?
Well, no, you're private.
No, I'm like, okay, I'm Joanne Fabric.
Well, therein lies the controversial rub. If you can refuse. One can refuse to ascribe or to put certain messages on or do certain things, right? In that sense, that wouldn't necessarily be violative of an anti-discrimination law. That was the debate in the Jack cases, whether or not those individuals who said, no, we're not going to make those cakes for you, were they objecting to the message on the cake, or were they refusing him because of his status? I don't have a good answer for that either. Yes.
So what I'm wondering, is there any difference when it comes to someone's religious sincerity between information that is voluntarily offered to that person versus information that is sought? So for instance, if Phillips doesn't seem to have come up, but would have had been able to show a history of, oh, I always ask, who's buying this cake, right? Mm-hmm. And that's sort of if I identify as a Christian, then if, someone who is, I don't know, like a Satanist tells me they're buying, I ask, and then no, thank you, right? Versus it seems like they got into this minor argument, but never got into an actual discussion of the product, as you stated. Yeah. Where he, because they said, it's a mother and son buying a cake for a same-sex post-wedding reception. Yeah, right.
Well, I think that, actually that happened after the decision, or something like that, similar to that happened. Someone came to the cake shop and asked him to make a cake because he had gone through a gender transition and wanted him to make a cake, and he had described to Jack Phillips the kind of cake that he wanted, and then that's when Jack Phillips said, no, we don't do this. I don't do this, right? So that presented another type of case. That eventually got settled. Yeah.
But it's like at what point the refusal happens, right?
Right.
Like it seems as if it happened after a description as opposed to immediately upon the subject presented.
This case, history is going to, I think, can safely say, is going to say that this case has little precedential value, but it is extraordinarily a head scratcher to me. Yeah. So, it seems like you have to get to the question. Any other questions? Great. Hey, thank y'all very much. Okay.